My name is Bob Duffy. I'm the CEO and President of the Greater Rochester Chamber. I'm joined today by, first of all, Scott Osborne, the President of Fox Run Vineyards and co-owner, Stephanie Woodward, who is the CDR Director of Advocacy here and does a great job, and Todd Schitteman from Nixon Peabody Council. And we are here to talk about a rash of lawsuits that have really emanated throughout our state and across the country relative to ADA issues and compliance relative to website accessibility. This has been something that's gone on. We feel very strongly that these lawsuits are being promulgated by a very small number of law firms. There are about 2,250 suits across the country. There are over 1,500 filed in New York State alone, and over 400 by one single law firm in Manhattan. These suits target small businesses, wineries, to be exact, as of late. And what the suits are doing is sending a complaint or a letter to the owners of the businesses saying their website is not in compliance with ADA requirements, and in some instances offering a $10,000 settlement. I want to thank Scott Osborne, who brought this to our attention. Scott is a member of the chamber and a friend. He brought this to our attention. And one of the underlying issues here is that with the money that is being brought in from these lawsuits, it is not going to promote greater accessibility or support disability rights organizations. It's going right back to whoever the plaintiffs may be and these respective firms. Chambers here today, we are here to fully embrace and support accessibility. So a big part of today is to help educate our businesses. We are urging those, if you are served with such a lawsuit, to seek counsel. I'm not a lawyer. We'll be hearing from one of our attorneys momentarily. But to seek counsel on this before you settle. Some of the areas that we have found that have been egregious are companies that have been served with these lawsuits, claiming their website was not accessible. In some cases, those websites were accessible and did meet standards. The ADA, ADA is here to ensure that we have compliance and accessibility. It is my understanding that if you fix the problem, by and large, there should be no damages associated with that, but I will defer to counsel to talk about that. But this is an issue that we feel is plaguing small businesses. It is people that are making quick decisions to pay a fee, a $10,000 settlement fee, versus hiring an attorney and going to court. But it is not really focusing on a greater issue of accessibility. And so we want to, first of all, let people know the Center for Disability Rights is a fantastic organization. They are a great resource right here in Rochester to help. You have certainly respective attorneys that they may have, who people may want to reach out to, but please to seek counsel first before settling, and to have their websites examined. We have experts right here at CDR, one who is in the room who did look at our website already. The Chamber is reviewing its own website. But one of the things that we feel is most egregious is people did not know they're hit with a lawsuit. I think people would want to know if they are not in compliance, if they're not accessible. You want to be accessible as a business and understand what you have to do to get there. And that is the bigger issue, is education and support for accessibility, not going through this route, seeking a quick fix and again, monies to settle a lawsuit, especially when those monies are not going to serve a greater good for accessibility or disability rights organizations. Some of the things we're just going through to kind of bring us to a close on my end. We're encouraging all our members and trying to educate them that we have resources right here that can answer their questions for them. Review your website, but also other areas of accessibility in your respective buildings. We want to make sure that all our businesses are accessible to everybody. So this is a great opportunity to reinforce those things. Again, we're asking people, do not just jump to a settlement. Seek counsel, seek your own attorney, seek counsel, seek help here at CDR. And we are really proud to partner with the Center for Disability Rights. I've had a history with this organization going back to my time as mayor. Proud of that history. It's a great organization. And they are here to help. We met here about 2 weeks ago, and just their insight, their support, and I'll let CDR talk about their own position on this, but it is really, to me, it's refreshing to hear their position. They want these issues fixed. They want accessibility put forth. but they in no way have supported these quick hit lawsuits that really just look, in many ways, just trying to take money, and money that does not even go to helping a greater cause. So with that, I think first Scott Osborne, who's the owner of Fox Run Vineyards, who brought this to our attention. Scott first, and followed by Stephanie, and then by Todd.
Bob, thank you very much. Thanks for the invite here and the opportunity to speak about this. Just to give you a little background, I'm a member of Wine America, which is the national policy board for the wine industry, and I was at the national meeting in Texas in November. Yep. Slide right in.
I'm trying to be accessible.
Yeah, there you go. No problem. Ready?
Yep.
So I was at the national meeting in Texas, and during the meeting, this issue of lawsuits was brought up about our websites being non-compliant. And I immediately, when I returned home from Texas, I sat down with my staff, said we have to check on this because it's, we want to make sure that we are accessible because, people have money, we want to sell our products to everybody. And so we started working on it with our web person who we've used for many years. And this is a long process. It's unbelievable how long a process this is to fix something like your website. And so as we're going through it, I all of a sudden had a number of phone calls and emails from attorneys down in New York City saying, Mr. Osborne, you're being sued. Would you like us to defend you? And I was totally taken aback by that. And I didn't get served for another 3 or 4 weeks. And at that point, now I have to deal with a lawsuit. And fortunately, one of my partners is an attorney, and so he's taken the lead on this. But I just feel that this is wrong, because if that person, we were in the process of trying to upgrade our website, and if I had been given a letter, a notification saying, hey, Scott, your website is, it's hard for my client who can't see to access your website, and these are the ways that you can go about and cure the problem, I would have done it immediately, or I would have at least started the process immediately. We've been working on it. We've been working on it for now for almost 5 months. We found a company that specializes in ADA compliance, and they have looked at our website, and they've had people who are vision impaired review our website to tell us all the problems and all the spots that they can't use. And we hope to be up and running with a new website within the next month. And I just think that when we have regulations like this and there are changes that in technology and stuff, that there has to be some sort of education or educational process that says, hey, here's a problem. All you businesses need to fix this problem. And then I also think that before a lawsuit such like this, there should be some sort of notification that's telling me that I am, my website or whatever is not working properly, and I should be able to fix it and have an opportunity to fix that.
Over to Stephanie.
You want me to move over to them? Would that be easier?
Let's do it with this gentle carrier.
But she's going to move over to the center.
All right. Good morning. Yep, good morning. My name is Stephanie Woodward. I'm the Director of Advocacy here at the Center for Disability Rights. And at the Center for Disability Rights, We strongly support the Americans with Disabilities Act and the notion that all businesses should be accessible to disabled people in all forms of the business, whether it's a brick and mortar store or a website. However, we have never supported lawsuits that seek damages but do not seek to fix the underlying access issue. We are here to help any business to understand what their requirements are under the ADA or any other law that has access requirements, and even how to go above and beyond that for best practices of accessibility. And we always want to be a resource to the community, but we will never support a lawsuit that seeks damages but does not seek the access to actually be implemented. And that's where we see an issue with these lawsuits. These lawsuits tend to give disabled people a bad name, when in fact it is not the entire disability community that is going out and putting forth these lawsuits. It tends to be law firms that are the driver on this. And as an attorney, I can tell you I'm just as disappointed in my profession for this. No business should be sued in the name of disability rights that doesn't seek to actually address a disability rights issue. We at the Center for Disability Rights are fully opposed to any sort of notification requirements in any sort of statute. However, because we believe that the ADA and other laws have been around long enough, that businesses should see this as a part of doing business is to be accessible. But we also believe that if you have any questions about how to do that, we are here as a resource to help you get there. So that is our main focus, is to ensure the businesses become accessible. We will support lawsuits if the lawsuit is genuine and the end goal is to actually get the access. But we are also very open and wish that businesses would choose to become accessible without a genuine lawsuit coming forth. But again, the disingenuous lawsuits are nothing that we'll ever support, and we hope to see an end to that by helping more businesses become accessible before something like this comes to their door.
Todd is our last presenter, so I'll do my shifting one more time.
This is gonna be really interesting when it comes time to ask questions.
I think
We're all just gonna get in a circle.
It's Bob's co-work after the day.
Hi, I'm Todd Shinneman. I'm an attorney at Nixon Peabody, and we've assisted a number of clients who have been sued or been presented with demand letters related to website accessibility. From the legal standpoint, of course, the ADA was passed to require public accommodations to be accessible to those with disabilities. So the initial question is, well, is a website a public accommodation? And in fact, many courts have ruled that a website in and of itself can be a public accommodation, even if it doesn't have direct connection to a bricks and mortar store. So in many cases, the initial determination will be that yes, a website is a public accommodation, but that's not always the case. There are some companies that will have websites that aren't generally purposed for use by the public, and may not be a public accommodation under the law. So that's one of the things that we often look at initially when assessing whether the lawsuit is appropriate. The next question often is, well, what standards are applicable? And one of the frustrating things to our clients in these cases is that there are not a set of regulations that say this is specifically what you need to do to make your website accessible. And the Department of Justice, the Federal Department of Justice, was in the process of putting together guidelines that would have specific requirements. In 2017, they abandoned those efforts. And so we don't have a specific set of guidelines that companies can follow to make sure that their websites are accessible. Now, there are some guidelines that have been provided by other organizations that have been generally accepted by many courts. The Web Content Accessibility Guidelines put out by the World Wide Web Consortium have been accepted by a number of courts as compliant. That is, if you comply with those guidelines, then you comply with the statute. But we do not have a specific set of regulations put out by the government that say what is it that specifically you need to do. But those guidelines are very useful, and for companies that have not yet been confronted with this, those guidelines are a good starting point to look at to see whether your website is accessible. If confronted with a demand letter or a lawsuit, of course, each case needs to be addressed specifically on its own merits, and there are defenses sometimes available. As I said, maybe the website is not a place of public accommodation. Maybe the plaintiff does not have standing to bring the lawsuit. Sometimes these plaintiffs are people who might come from, be pursued by a plaintiff's attorney in another state. Did they ever actually try to access your website? Did they ever actually have any opportunity to use the goods or services that the company provides? So sometimes there are arguments that the plaintiff, him or herself, does not have standing. But as I said, each case needs to be addressed on its own merits, and we certainly advise all of our clients, to the extent that they haven't yet been confronted with this, to take a look at their websites and get a good technology expert and consultant to look at the guidelines. Those WCAG guidelines are a good place to start, and to try to make sure that they're compliant before they do get hit with a lawsuit or get a demand letter from an attorney.
I'm gonna shift these back and then I'll kind of crunch in for questions. You have two attorneys and a winery owner here, so and just before you get questions, maybe a final comment, moving a little closer. I want to applaud Stephanie and Bruce Darling and CDR. I sat here 2 weeks ago for a meeting, and they really want to fix the problem and be a partner with businesses in this community to make it more accessible. I think that, to me, just shows their integrity. But I also want to say, on the other side, they shared a story of a business here that after months, if not years, of attempts to make it accessible, refused to, and we take that very differently. I don't support that at all and will not support it. We'll work with our members, but I think this is an opportunity that we're saying we want to educate businesses that may have no idea their website is not in compliance and want to be in compliance. And as opposed to responding to these lawsuits, and again, they're pretty targeted and coming from just a very small number of law firms trying to help fix the problem. So part of it is getting the word out to businesses, and we're going to work through our channels. I think it was mentioned about somehow codifying these rules. We want to work with CDR. Senator Diane Savino from the state Senate has shown an interest in this as well. So looking at ways, maybe through not only our federal leaders, but also state legislature, to come up with some guidelines that we can have basically implemented and be able to follow for businesses. So with that, I'll just open it up to any questions.
I guess I'll start with a legal question. What is it about the wineries in particular that people have an issue with the websites? Because I know you were part of, I saw another article, trade organization, that a number of wineries across the state got hit. So what is it specifically about their websites that there seems to be a problem with?
It's probably not a question of whether websites of wineries, generally speaking, are non-compliant. It's just a matter of the plaintiff's attorneys going after a particular industry, and this happens in any number of areas where plaintiff's attorneys catch on to something that they can then replicate across any number of cases. And in this situation, they've realized that wineries typically do have a bricks and mortar operation. They typically do have a tasting room or some other place where people may come to buy the wine, and they all have websites as well. So it's an easy kind of industry to identify and to find. Everybody can find a winery by searching for it, and to identify them and to look at the websites and then determine, oh yes, there is a place where people can go to actually buy the wine, and that helps with the plaintiff's case because to the extent that you can tie the claim into a claimed inability to use the website, which then impacts the person's ability to take advantage of the opportunity to go and visit the winery because they don't know the information that's provided on the website. They don't know, directions, or they don't know the types of wines that are available. So that impacts their ability to access the actual winery itself. And that, I think, is one reason why we've seen so many of the wineries be hit with these claims.
I think Scott would be a good person to answer, but I'll add one thing. Most wineries are small businesses. Scott is really, he's a farmer who has a large vineyard. They grow grapes. They're not these large organizations, and to take time off to travel, if the suit is filed, if it's in New York City or elsewhere, they don't have the staff or capacity sometimes to do that, so it's easier to write a check for $10,000 and have it be done with. But as we've said, it does not fix the problem and really targets unfairly certain businesses. I'm a SUNY trustee. This came up at a recent SUNY meeting. We have colleges and universities that have been also targeted. So as we discussed, I think they're looking at certain industries, and if there's traction in some, and I'm sure if people are selling quickly and it's a target-rich environment, you're seeing that. But a lot of it's just trying to educate people. I think we are seeing people, unfortunately, victimized on both ends. Those that want access to a website, they can't get access, and those that really, if they knew better, could provide it, but don't know better until this. And I think a lot of time and effort and money is being spent and not in any way addressing the problem.
I'm going to come back to you because Stephanie's closer to the mic, so if you don't mind. So what do you look for on a website to see if it is if it is able to be accessed by visually impaired people? I guess, when we were sort of talking about this story this morning in our newsroom, we said, okay, well, we have videos and they have captioning, but are we in compliance? I mean, I don't know that anybody really knows that isn't visually impaired what you would want on a page.
So this is a really good question, and since we had our meeting with the Greater Rochester Chamber of Commerce, Justin Young, who is one of our advocates here in the room and is blind, is creating a top 10 list of what are the top 10 easily identifiable things that are on your website that might not be accessible. So that's not going to make you fully compliant, but it is going to help you enter that world of what are we looking for. So one of the things is it screen reader accessible? Blind people use technology that reads the screen to them. If it's an image and there's no description of that image, the alt text, if you hover over, there's usually, if you do it right, it might say person standing in the grass, or it could say XXX JPEG. XXX JPEG is not going to be accessible, whereas an actual description of the image is. If you can highlight the text on your website, that is a good indicator that it may be accessible to a screen reader. But say you scanned a PDF in, and it's an image of the document as opposed to if you take a Word document and save it as a PDF, you can still highlight the words on the document. The image is inaccessible, where you can highlight the words is accessible. So it's a lot to get into, and that's why we leave it to our experts, such as Justin, who is blind, and we would be happy to send this document out and also make it available through the Chamber of Commerce so that people can learn about how they can start to become accessible and then get deeper into the regulations after that.
We have a great communications director who's going to be working with us and partnering with CDR to get this information out to all of our members and to get out even beyond our membership.
Okay, I'll have you come up if you don't mind. I guess, just from a business standpoint, you get this letter in the mail. You already sort of heard about it at the trade conference, right? And so you're like, why do you think? Did you compare your website to others in the Finger Lakes, and there's something different about it that you would have gotten, or was this person who sued, in your knowledge, wanting to come to your winery in particular for some reason? Why do you think you were picked out of the crowd here?
I have no idea. There's no rhyme or reason. Now, I've heard stories in New York City with art galleries, and they just started in A's and B's and C's, and they went through all the art galleries and sued them all. We're not the only, wineries are not the only ones. There's bed and breakfasts are getting sued, restaurants. Part of the issue that I see here is that they're going after small businesses who can't afford to fight. I mean, the cost of attorney's fees, and I could probably say that, of going to court, going to a federal court, you know, you need an attorney who can speak in front of a federal court. The cost is so far out of the range for a small business that it's settle, okay, how much do you want? You know, and then they start out at a huge number, and you just start working until you get something that you can afford to do, I think. And I haven't reached that point yet. You know, I just know that I don't have the money to fight this, you know, for whatever reason. You know, it's just, I don't have the money.
Do you feel like you're being extorted?
Well, definitely.
What, I guess, what, in the lawsuit, was there any requirement that you fix the problem, or were they just looking for money?
No, they in the lawsuit, they say, they list a number of reasons that I'm out of compliance, and then they may actually make a suggestion to go to become, actually they said I was not compliant to the WWWC, whatever it is, which is the World Wide Web Consortium standards, and so we immediately started working on that. When I first heard about this, I came back and we removed all our videos because they didn't have subtitles. We put on an accessibility statement which said, listen, if you're having a problem, please give us a call, you know, because we are in the process of changing our site. So we were actively going about to do this, and you know, and then we got sued.
How much what is the cost? I mean, is it expensive to make your site compliant?
It depends on all the problems that your site might have, you know, and it's not cheap. I mean, not cheap for a small business. It's probably going to cost me $10,000 plus to eventually get everything straight. But
So it's $10,000 for you to fix it, and they want $10,000 on top of that.
or whatever they probably want a lot more than that. But, no, it's, yeah, and then there's attorney fees on top of it, and my understanding is that not only do I have to pay my own attorney, but I have to pay the other attorney that's suing me, and so it just, you know, the costs just add up, and I think the reason people settle is because we don't have the money to take it further than that, you know.
Justin is an expert, and I think Justin pointed out at our meeting at one point that there are websites that are being claimed not to be in compliance that actually are. And I think he has a level of expertise that he himself has offered, you know, and certainly as a resource through the center here for businesses to reach out to, because not only here, but also on a national level, the organization is affiliated with can give you a good sense. And the top 10 issues that they've mentioned, we'll communicate those to our members. I think the point is have people check, and it be through the center here, through your web provider, to make sure you're in compliance. We want compliance. That's what, but we don't want under the threat of paying and then still not being in compliance. We want to make sure that happens. Trying to preemptively educate people that maybe weren't thinking about this, but we need to reinforce that they should think about this, because they're in many ways cutting off a large section of their potential customers. So I think it's not the issue itself, it's how it's being done that we have really fought with.
I would like to point out that making your website accessible is much like making your business accessible physically.
Mm-hmm.
If you plan from the start, it might not be any additional money at all because you planned for it. But if you didn't plan for a ramp and then you build steps and then you build a ramp, it can be more expensive. So while businesses are reevaluating their own sites to become more accessible, new businesses should think about this from the start, because it can be a lot less costly if you just become accessible from the beginning.
So off that point, so you have the ramp built at the beginning of your business. Things change every day. You might be updating your website. You might be putting something on. Something falls through the cracks. One day, you know, it happens. Someone made a mistake. Does that mean they're not in compliance anymore? I mean, I don't know if you can answer that. But you know what I mean? Like, websites are ever changing, I guess, and you might have someone doing it. They just made a mistake. They forgot to. Like you said, with scanning the PDF, they just didn't think about it that day. Are they not in compliance now?
There are companies out there, we happen to be using one called User First. They have software that once they get you in compliance, that software checks it every day And, you know, if you do make changes to your site, or if there's changes in regulations, that they're able to either fix it or let you know that it needs to be fixed.
I want to promote CDR. We have a resource right here, right in the heart of our city, that you can call and reach out to people right here. They can offer their expertise as well. So the resources are there, and it could be a web provider, as Scott mentioned, or calling CDR. They've been great partners with this, and you know, again, they want to see this fixed, but even start here. And we learned so much meeting in this room a couple of weeks ago about some of the issues, and the first thing we did is go back and look at and Justin did look at our website. We want to be in compliance. Just never gave that a thought until this came up, and that's part of the message here, is just communicating this and helping to educate people. And we discussed ways that we can have an ongoing relationship with CDR and communicating to our members through forums, newsletters, and just getting the word out that just, you know, really reinforces what we should be doing. It's good business to do this, and I think it's a great point about planning ahead to make sure you are accessible, because if not, you're losing customers.
And I think that, you know, people have to understand another part of this, and that, you know, I'm a business, all the other wineries are business. We sell a product. You know, we don't want to eliminate anybody, you know, because that's cutting off potential income. And, you know, it's, you know, and we want to serve, you know, our customers. And if we can't serve them, you know, we want to know about it. And just finding out, and a lawsuit is the wrong way to find out about that, you know, especially if you actually don't know what's going on. And so I think all of this is, you know, CDR and their training and the fact that they can help out. I think all businesses that are actually selling a product want to be accessible, because we all have, you know, ramps, and we all have bathrooms that are accessible, because we want our customers to be able to come in and enjoy what we have to offer. So.
For those who pay the $10,000, is there any fail-safe in place that these guys in New York get a check, and 2 days later they call you up, we're gonna sue you again because you still haven't fixed your website? I mean, what protects them after they pay the $10,000?
Absolutely nothing. They can certainly be sued again for not actually having the access. So that is why, instead of settling, you should always seek counsel, but also, most importantly, address the access issue at hand.
But like you said, it takes a while. It's not just an overnight.
It takes a while, and I know of a number of wineries down on Long Island that have been sued 2 and 3 times, and you know, it's just not right. I mean, it's not right when you're actually out there trying to do the right thing, and then somebody is doing a money grab, basically.
Do the courts recognize that? If you're in the process and get re-sued, do they say he's working on it or not?
Yes, potentially. I mean, the relief that's sought is called injunctive relief. That is, that you have to do something in order to fix the problem. And if you immediately initiate changes, you could potentially what's called moot the lawsuit or make it go away by making the changes that they're asking for. And it does take time, unfortunately, but sometimes, especially if you get notice of the problem or the claim before a lawsuit is brought, you could make changes and then there's no more lawsuit. And same thing can happen even during litigation, depending on what the claims are and the statutes that are sued under. You may be able to moot those claims by actually making the changes.
And when I keep, one of the issues about it taking a long time is, if you think about it, you know, how many thousand of lawsuits have been happening, and a company like User First, I'm in line. You know, there's only so much resources that they can put onto your website, and so I'm in line behind maybe 10, 15 other companies. And so, you know, I have to move slowly up to the front of the line before I'm going to get everything taken care of.
Do you think there should be something like when you're in a town, there's ordinances, if you don't have something right, someone comes and kind of tells you and you get a warning, and then if you don't comply within a certain amount of time, I mean, there's really nothing like that on the web, right? I mean, it's just kind of...
No, that's sort of one of the things we've been asking Albany about, is if they can come up with some sort of legislation that would, you know, require a letter that says you're out of compliance, and, you know, you should fix it this way, or something like that, and then 6 months to take care of it. And if you don't take care of it in 6 months, shame on you.
I do want to be clear, the Center for Disability Rights is fully opposed to any such legislation. We do believe that the ADA has been around for 29 years now. It should be very clear to businesses that you have to be accessible. However, we don't believe that people should just go around filing lawsuits just to get the settlement. That's our issue, is that you can actually moot out the suit by becoming accessible. So fix the access issue, but when you ask people with disabilities to tell you to be accessible, it puts a burden on disabled people that we shouldn't have to have. And no one would question if a different person of a marginalized status was denied access. No one would question a lawsuit that they would bring. So you shouldn't question genuine access issues that are brought by disabled people. The ADA has been around 29 years, although I do believe that the state can put in regulations that clearly define what access is for a website, because as technology continues to change, the ADA doesn't explain as well what applies and what doesn't, because in 1990 I don't think that there was a lot of talk about accessibility in websites.
Well, that was gonna be my next question, because when that did come out, websites were, you know, Al Gore was still inventing the internet at that time, so. So how, I mean, you know what I mean, like, so if you have a building and it's not handicap accessible, what happens? Right away, does someone step in? Like on a building, or does?
So we would love it if building inspectors would actually look for accessibility issues. The problem is that they don't do it either.
Right.
So while we do have ordinances that say you have to be accessible before you start opening your business, there are plenty of businesses that are approved every single day that are inaccessible. At the Center for Disability Rights, our process is actually to send a business a letter. It's not required by law, and we do not support it being required by law. I want to be clear on that. But we send the business a letter saying, hey, did you know the ADA has been around for about 29 years now? Here's all the ways you're inaccessible. Here's what we would like to see and how you can get there. And we want to help you get there. Call us, and we're going to help you. And if they don't respond, then we might follow up with a phone call saying, hey, did you get our letter? If they still don't respond, we think it's very nice when we have a protest on your front lawn, because that's cheaper for you than hiring a lawyer. So we might protest you and get a bunch of media cameras, and then you might build that ramp. And if you don't do that, even after a protest, then we will sue you. So we go through a lot of different steps to try to convince a business to just do the right thing and follow the law before we would move forward with any sort of lawsuit. But we don't think that that should be required. We just do that as a service to our community. So yes, our protests are a service to our community.
But there's no fines from the town on that, is what you're saying?
I'm sorry?
Since it's an ordinance, shouldn't the town be able to fine them, or no? I'm just asking.
Well, there are requirements, but we don't see any sort of town enforcement. We did see with one suit where they actually tried to blame the city for not allowing them to get a permit to build a ramp, and it turns out they never submitted a request for a permit for a ramp. So oftentimes they will actually try to blame the city or the town for their inaccess, when in fact it is the business's fault.
How often do you send those letters? Is it every day? Is it every week?
You know, we usually, when we have a person come to us saying, I really wanted to get into this business and I couldn't, is when we would send them. So it's not like we are out there saying, you know what we want to make everybody uncomfortable today. Although we don't think it would be a bad thing to inform people. It's just our capacity doesn't allow us to go out and evaluate every business. But if a person does come to us, we will not just take their word for it. We will send someone out, take a look at it, and say, you know what, this isn't accessible. Let's start moving from here.
Okay.
Thanks, guys.
Thank you very much for coming. And I want to thank really Stephanie and CDR for hosting us.